recording today's webinar, and so you will have access to come back and hear it again, to revisit any of the information you've gotten today. But again, really pleased that we are able to pull this together, pleased that so many of you are able to attend, and think you'll get a lot out of this. So with that, let me turn it over to Erin Childs. Erin is the Executive Director of the Pro Bono Partnership Center of Ohio.
Good morning, everybody. And Mike, thank you. Thank you to United Way for co-hosting this with us. We're thrilled to be able to bring this information to our nonprofit community. I'm looking at everybody who's on. I'm excited to see Jenny Berg from Leadership Council for Nonprofits, and also Inspiring Service, Cincinnati Cares on here, other great organizations doing important work as umbrella organizations. We partner with them a lot. So thank you to everyone being here. For those of you that aren't familiar with Pro Bono Partnership, we are 5 years old here in Cincinnati. We're the third one nationally, and our mission is to strengthen our community by engaging over 620 different volunteers here in Cincinnati and Dayton to provide over 200 local nonprofits with free legal services that are tailored to your business needs. The types of legal projects that we assist with, they are all corporate in nature. Obviously here today, we're here to talk about employment, how nonprofits like all of yours can keep not only your workforce healthy, but also continue to do the important work that you're doing serving our community. In order to qualify for our free legal services, there are a few qualifications. You have to be an established nonprofit on the ground, helping those members of our community that need it the most. Located in Cincinnati or Dayton. I know right now we have some people from Indiana and Kentucky on the phone. We're not there yet. And you have to demonstrate that you're unable to pay for legal services. For anyone who's not a client, I encourage you to go to our website to look at our client qualifications. We're working really hard right now to kind of speed through fast track applications to get you the services that you need. What we've been able to put together in a week, we have webinars like this one. We've been sending out weekly news alerts and updates that talk about the changes in the law. Liz Stock, our speaker today, gave this presentation last week and had to change several of her slides just in a week because the laws have changed so quickly. We want to make sure you hear about those. For our clients, we have an employment helpline for COVID-19 response. We presume there will be many specific questions coming out of today's webinar. And what we want to be able to do is hook you up as quickly as possible with a subject matter expert. We're kind of circumventing a lot of our traditional process that we'll tell you about when you apply to be a client. But in order to get you the answers you need to be able to do your jobs, we've set up this helpline. I encourage you to sign up to receive our newsletters. The next slide gives you our general information email. If you have any specific questions or you just want to join our mailing list, please email there, or you can go to our website. Inspiring Service, Cincinnati Cares is putting together an awesome new website for us that we hope to launch here next week. I want to again reiterate that what Liz will be talking about today is the current law as of today. So if anyone is listening to this after the fact, just know that the laws change quickly. A lot of what Liz will be talking about won't change because they're basics that happen in times of crisis. But in terms of the specific laws, make sure to check with counsel before making any big decisions. So without further ado, I want to introduce you to Liz Stock. She is of counsel at the law firm of Bricker and Eckler. She is also one of Pro Bono Partnership of Ohio's favorite volunteers. She's one of the leaders of our GROW PBPO Advisory Council. Barka Patel, our Director of Education and Senior Counsel, will be navigating all of the questions that you are typing into the group chat. She'll try to culminate them. If they're very specific, we'll probably not be able to answer them today, but please, if you need more clarification on something or have a general question, please type that in there. So without further ado, Liz, take it away.
Thank you, Erin. Thanks for the introduction. Thank you to PBPO and United Way both for hosting this. I'm very glad to be with you all today. I'm going to start off with a quick disclaimer, although I think Erin and Matt covered it a bit, but this presentation is not legal advice, so please do consult with your counsel before relying on any statements made in this presentation. And I won't say it again. I think Aaron and Matt covered how quickly things are changing. I was amazed at how much information that I had in this presentation about a week and a half ago, I had to take out or alter substantially because of so many new things that have developed over the last week. Our agenda for today, I'm going to quickly touch on Ohio's stay-at-home order and some of the highlights of that order, talk about briefly the changes in Ohio unemployment law, cover a very high-level reminder of some of the basic federal laws that are important to keep in mind as you navigate various employment law issues related to COVID-19. I will spend a little bit more time on the new federal law, the FFCRA, or the Families First Coronavirus Response Act, that was signed into law last week. And then I would like to spend the bulk of our time today on some of the frequently asked questions that we are getting from organizations like yourself. And I will go from there to give you some focus in on some key resources, governmental resources. In addition to the PBPO page, there are some important governmental websites that you all should be checking on a regular basis, given how quickly things are changing. And as Matt mentioned, we'll be taking questions throughout the presentation. But if we have time at the end and there are some remaining questions, we'll leave some time for Q&A at the end. So a quick note on Ohio's stay-at-home order. It was effective earlier this week on March 24th. In short, it requires that individuals stay at home with some exceptions for leaving your home to perform certain essential activities, such as food purchase, medicine purchase, medical care, outdoor activities, and a variety of other essential activities that are spelled out in the order. The other exception is individuals can leave their home to perform essential business and operations. That is defined at length in the order. What the order does is it's incorporated the U.S. Department of Homeland Security's list of essential industries, plus added some additional essential business and operations, including essential government functions such as police, fire, courts, military, etc., healthcare operations, essential infrastructure, food services, grocery stores, for example, gas, financial institutions, and a wide variety of manufacturing operations that support other essential businesses and infrastructure. For entities that are an essential business, the order requires that they use only essential employees in conducting those operations and comply with social distancing guidelines that are spelled out in the order. For organizations that are not an essential business, they need to shut down essentially, but can remain open to the extent necessary to perform minimum basic operations, which are those activities that are necessary to maintain the value of inventory, preserve your physical structures, equipment, provide security, process payroll and benefits, for example. I encourage everyone to take a look at the full order. You can visit the Ohio Department of Health's website for that order. It's at coronavirus.ohio.gov. And I understand we do have a few organizations on the call from Indiana and Kentucky. My understanding is Indiana has a stay-at-home order as well. I am not as familiar with the details of it, but many of these state stay-at-home orders are very similar. And Kentucky, although I don't believe Kentucky is instituted a stay-at-home order, it's reached effectively the same result with shutting down of all non-essential businesses. Real quick mention on Ohio unemployment. It has been expanded somewhat to, it waives that initial 7-day waiting period that typically applies, and it expands and provides unemployment to employees who may be quarantined or isolated by a medical provider, a health official, or employer, affected by a shutdown of employer operations due to COVID-19, or laid off because of a COVID-19 related loss of production. Really, the key here is there's a lot more to be said about the Ohio unemployment, but if you have detailed questions, go to the Ohio Department of Jobs and Family Services website. They have made a form available for employers to provide to employees who you think might be eligible for unemployment. There's some good Q&A on their website, and that form includes this mass layoff number, or WARN Act number, that is on the screen here. And the employees, if they provide that form and they provide that number, it helps to expedite the efficiency of their application. All right, now I'd like to turn quickly to a really brief reminder of some important federal laws. I will get to the new FFCRA here in just a minute, but wanted to quickly cover some other federal laws that we already have in place, and for you all to just keep in mind as you're making decisions that relate to this pandemic that might impact your employees. So first off, we have the ADA, or the Americans with Disabilities Act. I know we might have some small organizations on the phone, but this law and most of the others that I'm talking to will likely cover you. And if they don't, Ohio and other state laws also impose very similar requirements. So the ADA, for example, covers employers with 15 or more employees. And if you're smaller than that, Ohio law will probably get you, as it covers organizations with 4 or more employees. So the important things to keep in mind under the ADA are the accommodation requirements. A note here, the ADA only requires that organizations accommodate disabled employees. And having COVID-19 without more, with nothing else, likely is not a disability because of the short duration of the condition. Now, that doesn't mean you can ignore the ADA altogether. You can't, but this is something to keep in mind as you consider requests by employees for accommodations, and I'll get into that in a little more detail as we go on into some of our FAQs. Remember as well that the ADA prohibits disability-related inquiries and medical examinations. That is the general rule. There's an exception that is coming into play in a large fashion right now for if you need to ask those questions because there is a direct threat, meaning a significant risk of substantial harm to health or safety of the employees or others. And so this exception is being used right now to allow employers and organizations to ask a lot of questions and do a lot of things that you would not normally be okay under the ADA. And so the key here is just to keep in mind that this prohibition is still there, and to be careful not to go too far or go beyond what health departments and the CDC are advising and recommending. And last, I wanted to remind everyone of ADA's confidentiality obligations. So as you are receiving information, medical information about employees, be sure that you are taking all reasonable measures to keep that information as confidential as possible. Next, there's the FMLA. It's been drastically changed with the FFCRA, but again, keep in mind that the old FMLA is still there, and covered employers, that's those with 50 or more employees, still must provide leave for, and this is unpaid leave, for serious health conditions, as those have always been defined under the FMLA. OSHA, another federal law to keep in mind that requires employers to provide a workplace free from recognized hazards. So it's the OSHA's general duty requirement. And really the key here is just to make sure you are familiar with and you're taking all the reasonable steps to comply with all the guidance that's coming out from the CDC and Ohio Department of Health in terms of maintaining your workplace, keeping your workplace as safe and healthy as we all reasonably can. A quick mention of the National Labor Relations Act. If you are a particularly small organization, this federal law might not apply to you, but otherwise it does apply to union and non-union organizations. And just remember its prohibition against interfering with protected concerted activity, which generally means 2 or more employees working together to advance or address concerns they might have with working the terms and conditions of work. And OSHA and the NLRA will come into play here in the event you have employees raising objections, complaining about working conditions, refusing to work. Again, I go back to if you're following all of the guidance from the Department of Health and the CDC and you're taking all reasonable safety measures, you should be in as good of a spot as you can be from that perspective, and then just be sure you're not retaliating against any employees because of objections that they are raising. GINA, another federal law, prohibits asking about genetic information, and so just a note here that this genetic information is defined to include family medical history. With so much medical related conversation happening supervisors to slip into more detailed questions and conversations with employees and to start asking questions about the employee's medical condition or the employee's medical history and or their family member's medical history. And key here is just to make sure that you instruct your supervisors to really limit those conversations and not go too far down that path and getting into conversations about family members' medical conditions or history. And then last, the Fair Labor Standards Act, just a quick reminder that it very high level requires organizations to pay non-exempt or hourly employees for all hours worked. And if they're not working, there's no requirement under the FLSA that they be paid. And keep in mind, with your exempt employees, the salary basis test for remaining exempt, which requires that those employees receive their full salary for any week in which work is performed. And so I'll get into this a little bit later, but this will come into play as organizations are considering possible furloughs or reductions in work hours or days of work for exempt staff, and make sure that you are doing that and navigating it and paying those exempt staff appropriately under the Fair Labor Standards Act as you're making those decisions. And last, a brief mention, do not forget to always consider state law. For those of you who are organizations in Kentucky or Indiana or anyone here who has an employee working in another state, be mindful of any laws that particular state might have that require paid or unpaid leave beyond the federal requirements I'm going to talk about today, or that impose restrictions on lawful off-duty conduct. This was in here initially with the travel restrictions, although early on a few weeks ago, employers were making a lot of decisions about whether to allow somebody to come to work if they traveled to certain locations, and we were advising them to be cautious of state laws that might prohibit them from doing that. But we've now gotten to a place where it's almost mandated by either another state law that has preempted that or an order or the federal government, but so not as much of a consideration there. I'm going to pause just for a quick second before I jump into the FFCRA. Barca, any questions for me to address right now before I move on?
There have been a lot of questions coming in, Liz. Some of, some of the ones that I wanted to highlight. If an employee is requesting expanded FMLA leave because they have kids at home, is that something that needs to be considered?
Yes, and I'm going to get into that here in
Perfect.
the next couple slides, so I'll pause on that one.
Okay. Can
were
an
there others?
can an hourly employee work from home?
Short answer, yes. Any employees, you can have them work from anywhere. The key is if you have an hourly employee working from home, just be mindful about how are you going to have them track their hours worked and make sure that you are paying them for all the time worked. And be careful about giving them instructions. If you do send hourly employees home, send them home with the very clear instructions on here are the schedules. Do not work beyond this or after 5 o'clock, say, for example, or don't start working before 8. Make sure that they know that if they do work beyond that time, that they need to report all of that time so that they're getting paid for all their time worked.
Okay, I think that's it for now.
Okay, thank you. So I'm going to go into a little bit more depth on the FFCRA because it is brand new as of last week. It is effective April 1. If you're confused why I said April 1 and not April 2nd, because the initial statute that came out said it was going to be effective on or before or no later than April 2nd. DOL just put out guidance clarifying that it is now going into effect April 1, so that is a Tuesday, I believe. It covers employers with fewer than 500 employees company-wide. So you do look company-wide in counting up your employees. If you have 500 or more employees, you are not covered by this act and can sort of tune out for, for the next couple slides. There is an exemption for small businesses defined as those with fewer than 50 employees, but two important points to highlight here. One, that exemption only applies to what effectively ends up being the requirement to pay for up to 12 weeks of leave for employees who need leave to care for children. Let me back up just a quick second. The FFCRA is composed of two key separate laws. You have the emergency FMLA, so the expansion of the FMLA to include this additional reason for leave, plus Emergency Paid Sick Leave Act. One thing that reading two of those two laws together, it does is provide effectively up to 12 weeks of paid leave, like I said, for employees who need leave to care for children who are home because their school or daycare has been closed. And so it's from that component of all of this, that piece, that there is an exemption for small businesses, fewer than 50, if compliance with that piece of these laws would jeopardize the viability of the business as a going concern. Of course, you're probably all wondering, well, what does that mean? And really, for now, we have to just exercise your best judgment. The DOL has basically said that document why your business meets the criteria set forth by the department, which will be addressed in detail in forthcoming regulations. So we just don't have those regulations for right now. So like I said, exercise your best judgment and keep in mind that the Department of Labor has indicated it will be understanding and somewhat lenient in its enforcement, at least in the short term of these laws. It recognizes that employers are learning all of this in real time. And so as long as organizations are if you're doing a good faith effort to comply with all of these requirements, and if the DLL alerts you that you've done something wrong and asks you to make a correction, then promptly make that correction and promise you will be good in the future and comply in the future, that they recognize that's the best they can ask of organizations right now. So assuming you are a covered organization, then you look to which employees are covered. For the FMLA expansion piece, which I'm going to talk about here in just a little bit more in a minute, employees are covered if they have worked for you for at least 30 days. For the paid sick leave component, all employees of a covered organization are covered, with an exception, and organizations are permitted to excuse or exclude from these requirements healthcare providers and emergency responders. So let me break down those two laws a little bit further. The FMLA expansion provides up to 12 weeks of leave to care for a child if that child's school or daycare has been closed. The first 2 weeks are unpaid under the FMLA expansion, but as you'll see here, that they effectively get paid under the Paid Sick Leave Act. And the second 10 weeks are paid under the FMLA expansion at 2/3 of the employee's regular rate of pay for a maximum of $200 a day. Our current understanding, based on how this law is drafted, is that the FMLA expansion does not provide an additional 12 weeks. It's just another reason that employees can use their 12 weeks of FMLA. So, for example, if you have an employee who in the last 12 months has already used up, say, 6 weeks of FMLA for some other condition that was previously covered by the FMLA, they would only have 6 remaining weeks left. Again, that is current understanding. It's possible that Department of Labor changes that with the regulations that are coming out. So the second component of the FFCRA is the sick leave requirement, which provides 80 hours of paid sick leave for use by full-time employees. If the employee is part-time, you look at the average hours worked in the last 2 weeks to determine how many hours of paid sick time they have available to use. And there are 6 reasons that an employee can use paid sick leave. Those are the 6 reasons listed here on the slide. If the employee needs leave because of a government quarantine or isolation order, because a healthcare provider has advised the employee to self-quarantine. A quick note on number 1 and number 2, our interpretation right now is that the stay-at-home order is not a government quarantine or isolation order or self-quarantine order, that those the employee would need to show an order from the government or advise instruction from a healthcare provider that's specific to them or specific to their particular situation. A third reason to use this 80 hours of paid sick leave for full-time is if someone has symptoms of COVID-19 and is seeking a medical diagnosis. Fourth reason is if they need leave to care for somebody who is subject to number 1 or number 2, the government order or instruction by a healthcare provider to self-quarantine. And then the 5th reason is if they need leave to care for a child whose school or daycare has been closed. So basically that 5th reason is what it covers pay in those first 2 weeks that would otherwise have been unpaid under the FMLA expansion. And then there's this sort of 6th catch-all reason that right now is somewhat meaningless. We don't really have any regulation or guidance with any more detail, but basically any similar condition that the Department of Health and Human Services might later identify. The amount of pay is in parentheses there for reasons 1, 2, and 3. Employees taking leave for those reasons are entitled to their full regular rate of pay up to 80 hours or whatever the lesser amount might be for part-time employees. And there's a $511 per day maximum. And if they are seeking leave for reasons 4, 5, or 6, they are entitled to 2/3 of their regular rate of pay, and there's a $200 per day maximum there. A few other quick highlights. This paid leave is paid by you as the organization, as the employer, but there is a tax credit available. That tax credit is only available for paid sick leave that's paid on or after April 1st. So for organizations who may have been more generous or created temporary paid leave policies prior to April 1st, That time is not eligible for the tax credit, and it also does not count towards this 80 hours of paid sick leave that you have to provide starting on April 1st. Employers cannot require that other leave be used first. Existing PTO bank hours that might be available can be used to make an employee whole. So if, for example, they're only getting 2/3 their regular rate, they can use their existing PTO bank to make up that other third difference. There is no carryover or cash out, so any of this paid time that does not get used does not need to be cashed out, and it does not carry over beyond December 31st, of 2020. 2 days ago, the Department of Labor finally published, I shouldn't say finally, they're scrambling too, they published their poster that summarizes the Act's requirements. They are moving so fast. I think the initial version of that poster that came out had, they forgot the pay for childcare closures, so they had to amend their poster. So everybody's moving quickly, but that poster is available on the Department of Labor's website. And so I would encourage you all to look at that website for that poster, and they also have included some frequently asked questions related to the poster and related to this FFCRA generally. So I am next going to go into some of the most frequent questions that we are getting, but let me pause there to see if there are some questions specific to the FFCRA that I can answer.
We have is, what if employees can only work part-time because they're caring for children at home? Under the FFCRA, is there an ability to count 50% of their pay under FFCRA and 50% regular pay? How does that work, or is there not guidance on that yet?
That is a good question. We don't have guidance on that yet. I'm going to give you, based on how the Act is drafted right now, I believe that they would be able to use it for the partial leave that they need to take care of their child. So if, for example, they need every afternoon off or can only work part of the week, I believe this would be available for them to use this as sick leave, but a question that has not been answered yet. We are anticipating, I guess from what I'm hearing, I know the Wage and Hour Department of the Department of Labor, or Wage and Hour Division of the Department of Labor was seeking comments and questions from organizations like this. I think their comment period expires this weekend. So I'm hopeful that next week these guidelines will come out and provide some more direction. And like I said, recognizing that there is no guidance right now, I believe they've even said there's a 30-day sort of non-enforcement period, giving employers the option to really do their best for now, and as long as you adjust to the guidelines once they come out. Other questions?
There are many other questions, Liz, but in the interest of time, I think we'll let you move forward and maybe we can address what we can at the end.
Perfect. All right, so first question here is what should an organization be considering if it needs to reduce staff? This was not one of our FAQs when we did this a week ago, but given the stay-at-home orders and given the serious turn everything has taken, a lot of organizations are looking at their cost reduction options and how they may need to do that with staffing changes. There are many different ways to slice a staff reduction, and you really need to look at your specific business needs and your organization and what's best. But it could range from a mass permanent layoff of the entire organization, temporary layoff of or some or part of your workforce, furloughs, which is generally not a complete layoff, but perhaps somebody's days of the week that they work are reduced, or hours are reduced, or other reductions in pay, perhaps. So the two big considerations if you are in this position and looking at any of these options. Number one is non-discrimination concerns, or discrimination concerns, and making sure you are not discriminating. Think about how you will respond if and when down the road an employee challenges a layoff or a furlough or a reduction decision where all employees in a particular job title or category were not equally impacted. So if you're in a position where perhaps you have 5 individuals performing a certain function, but you really only need 2, and so you're picking and choosing amongst who is going to stay and who is going to go on a temporary basis. Plan now to put yourself in the best position to defend against a discrimination claim by having objective criteria for how you are making those selections. Perhaps it's by seniority, perhaps it's by, maybe there are distinctions in terms of maybe that somebody have a same job title, but there are certain functions that only certain employees can do and others can't. But just think through what those objective criteria are and document those. And you may even think about how much of that you can and want to communicate with employees in advance to lessen that concern that, well, I'm just being picked because you never liked me, or worst case, because I'm a woman, or because I'm the only minority on the team, or I have children. And you're trying to avoid having to comply with the FFCRA. And I mean that's the high level there on non-discrimination. The other issue is pay, and there are a variety of pay issues to consider. So the FFCRA and the paid sick leave requirements would not apply to people who have been laid off. It does not provide sick time because somebody, if they were laid off, and sorry, let me back up, if they are laid off now prior to this act becoming effective, and so that they are not a current employee, it does not, the Department of Labor has clarified, it does not apply retroactively. So give some thought to that. Are there reductions that may need to be made prior to the act going into effect on April 1st? If you are reducing hours or work days for exempt staff, again, keep in mind the salary basis test that applies to exempt staff. And so if they work part of a week, or part of a day, they are entitled to their full salary for that week. You can make some prospective changes. And so it might be that if, going forward for the next couple months, you are going to significantly reduce the number of hours or days of the week that an exempt person is working. You can prospectively reduce their salary amount as long as the weekly salary amount meets the minimum required under the FLSA, which is $684 a week. Also give some consideration to healthcare insurance coverage and premiums. That's another issue to think about during furloughs or layoffs. And here I am not a benefits attorney, and so this is one area that I'm not going to be able to go into too much detail on any specific questions, but the short answer is look at your health plan documents and consider how whatever action you are taking with respect to an employee impacts that employee's eligibility under your health plan. Does it trigger COBRA? Many employers are wanting to continue coverage during layoffs. Others might want to discontinue the coverage if they can. So again, look at the plan to see what the options are there. And I do know that there is the respective government authorities are providing some leniency on a very short-term basis for organizations to keep people on their health plan when perhaps they might not otherwise be covered or be eligible under the terms of the plan. So you really want to make sure you're consulting with your benefits legal counsel and looking at the plan documents for those decisions. All right, let me move on to the next question. What questions can you ask of an employee? This is where the ADA's prohibition against asking disability-related inquiries or conducting medical exams, and where GINA's prohibition against asking about family medical history come into play. As I mentioned earlier in the presentation, there is a lot that you can and actually should be asking now per Department of Health and CDC guidance, but keep in mind that there are still a lot of questions to stay away from. So it is certainly okay to ask someone how they are feeling or if they are experiencing symptoms. In fact, it's not only okay, it is encouraged currently. And so it is fine to ask somebody if they have any of the COVID-19 symptoms, but stay away from going too far down the road and asking about other conditions, underlying conditions, which you might be asking out of a genuine concern for the employee's health or safety, asking them perhaps if they have an underlying respiratory condition or immunodeficiency condition. Those questions are likely still prohibited under the ADA. And there is no direct threat exception for asking about family member health information under GINA. And so you should avoid those questions as well. And this is just a good time to remind your supervisors to stay away from having detailed medical conversations with employees. You really want to route all of those conversations to whoever it is in your organization who is responsible for HR, and in particular, have a point person or two that are responsible for triaging these employee issues related to COVID-19 and having these conversations with employees. What about, can I take an employee's temperature? This is a great example of where a week and a half ago we were advising that probably not, in the EEOC's guidance that was out at that time, which they had issued during the H1N1 virus, said no, that they said this is just like H1N1, it's not serious enough, and taking temperatures as a medical exam, and you shouldn't do that. Things have changed 180 degrees now, and not only does the EEOC has come out and said that it is okay to do this. The Ohio Department of Health, for example, and other states might be doing the same thing, actually recommend that employees their temperatures be taken and that they be screened for COVID-19. This is another place I really encourage you to look at the Department of Health website. They provide some good guidance on how to screen employees for COVID-19. Keep in mind, this is not an order. These are not mandatory requirements, but it's rather guidance, and so you need to just consider how it works best with your organization. At a high level, generally what the Department of Health is recommending is that organizations let people work at home if you can. Have someone or have the employee themselves take their temperatures each day before coming into work if they are coming into a workplace, and to send the employees home if their temperature is 100.4 or higher. If you have employees coming into a workplace and you're going to be taking temperatures for them, keep in mind some practical considerations. First off, keep in mind that an elevated temperature does not necessarily mean the person has the virus. Consider, unless you're having the employees just do this themselves, which I know that's the route our firm has gone. If you're going to have somebody be taking the temperature, consider who is going to do that, what instrument are you going to use to take the temperature. Hopefully this goes without saying, but obviously don't use a in-the-mouth thermometer and go from one person's mouth to the next. Try to take temperatures in a way that best maintains social distancing, and consider the need to keep any results that you get confidential, whether it's you as an organization taking temperatures or if you're having employees report an elevated temperature, remember that is medical information that needs to be kept confidential and shared on as limited basis as possible. Give some thought to what if an employee refuses. I think it's a matter of time before perhaps someone does refuse due to, say, a religious objection. How are you going to respond to that? My suggestion would be for that particular example, sort of go through your normal analysis that you would when employees have a religious objection, and perhaps make that accommodation and think of other ways that you can get the information you need. And there are alternatives to taking temperatures laid out in the Department of Health's guidelines. Just asking them various questions, including symptoms they might be experiencing. All right, can you as an organization ask somebody why they were absent? If you have employees, again, who are otherwise scheduled to work and should be working and they don't come to work, is it okay to ask why they were absent? And can you, if it was for a medical reason, require a medical release upon return to work? Yes, you can always, and you have always been able to ask somebody why they were absent. That's not a disability-related inquiry, and so that's a perfectly acceptable question. And the EEOC's most recent guidance says both of these things are okay. You can legally require the medical release, but be very cognizant about the burden that is currently being placed on our healthcare providers. And I think even the CDC and health departments are recommending that we not send employees to the doctor just to get a doctor's note to get sick leave or to prove that they have COVID-19. I mean, keep in mind also the lack of testing in certain areas as well. Can I send a sick employee home, and do I have to pay them? So if you have an employee who is demonstrating symptoms of COVID-19, absolutely, yes, not only can you send them home, you should send them home. And just a quick reminder that under normal circumstances, this answer would be a lot more complicated because of the ADA and not wanting to regard somebody as disabled. But normal rules are, at least in that regard, a little out the window right now. And so absolutely, it's fine to send somebody home. And in terms of whether you have to pay them, if you've sent them home, consider, you want to look at the FFCRA and look at whether any of those paid sick leave requirements apply. Look at state law that might apply. Ohio does not have a paid sick leave requirement. So if you have Ohio employees, not a concern there. Don't forget about your normal policies on PTO. And whether they would require pay. And perhaps you might want to, if they do require it and you're trying to make some budgetary cuts, consider whether you need to modify those policies, on a go-forward basis for a temporary period of time. And then again, be mindful of your obligations to pay exempt employees a salary basis. Another option for exempt employees on a prospective basis is to temporarily convert them to hourly and just pay them for hours worked. That's always an option. Are you required to let employees work from home? So this question assumes that you have not already asked or required the employee to work from home, and that you have not instructed the employee to not work at all, for example, due to a stay-at-home order. In other words, assume you are an essential business and the employee is essential, or the employee is needed to perform minimum basic operations, but you have an employee who's asking to work from home as opposed to coming into the office. Consider here whether, well, first a quick note on the ADA. Again, the ADA would not require this as a reasonable accommodation because merely having COVID-19 is not a disability. But don't forget to to take into consideration if they give you another reason, they have an underlying disability, an anxiety disorder, an immunodeficiency disorder. In that case, you might be required to accommodate them under the ADA. Most employers on the guidance that we are now receiving are allowing and requiring employees to work from home anywhere they can. But there are some jobs that really just can't be performed remotely. And so you may have to tell, in that case, the employee that they need to come in, and you would not be required to let them work from home. If you choose to, if you're modifying someone's job a bit and you're letting them work from home, but they're not really performing all of their essential job duties, you might consider putting something in writing to them that just notes that you're allowing them to work from home because of the extraordinary situation that we are in right now related to the coronavirus, and that you recognize that they might not be able to perform all of their essential functions during this time period. This will help you possibly put the genie back in the bottle a little later on when you then want these employees to come back to the office and they try to argue, well, you let me work from home before, why can't I continue to do that indefinitely?
Liz, on that note, can I ask one question that we've seen repeatedly?
Yes.
If the employee is at high risk for COVID-19, does that change that analysis at all? Does the organization?
It could.
Okay.
It could. In other words, if they are at high risk because of some underlying, now if it is age only, it does not. Does not change the legal analysis. Does it change, how accommodating you might want to be, perhaps, and that's just business decisions to be made there. But if they are at high risk because of an underlying health condition, you might need to consider reasonable accommodation. But again, even if they are disabled because of a condition, you only have to let them work from home if it's reasonable. And honestly, if it's reasonable, you're probably already allowing them to work from home. And if they have a job that truly cannot be performed at home, you're not required to pay them to sit at home and do nothing, or you're not required to create a whole new job for them. And so if they really can't come in, then it might just be that they take a leave of absence.
Okay, thank you.
Sure. Last question, I think there's two more, but I've covered the very final one, I think, already. And I know we're getting close to time here. Do you have to approve leave for a healthy but concerned employee? So, let's assume here that none of the leave obligations under the FFCRA apply. Let's assume telecommuting, working from home is not an option. And you are an essential business and this employee is essential and they really need to be in the office. But understandably, they're just concerned and they don't want to leave their home. Do you have to approve the leave? The question here is, A, just make sure that their request does not fall under the old FMLA or ADA, that they're not asking for leave for some other covered reason. And if they're not, if it's truly just I don't want to, I'm just generally nervous and I don't want to come into work, then you've got a business decision to make here at this point. You want to, of course, make sure that you are following all of the federal and state protocols on social distancing and that you are communicating those to this employee and to all your employees. And that's just general advice to be following anyway. Make sure that your employees know all of the different safety measures that you are implementing to make the workplace as safe and healthy for them as possible. And so if you are doing all of that and following all of the recommendations, it is okay to legally require the employee who just doesn't want to or just is general discomfort about coming in, to require them to come in or penalize them for failing to do so. But and I underline but here, you want to really closely consider the specific situation and weigh the need to have them come in, your business need to really have them come in or to penalize them for not coming in against the risk of a claim down the road if that employee does get sick. That's the concern, that you've told them to come in or you've penalized them for not coming in and they come in and then they get sick. Not going to opine on how successful a claim like that would be if you are taking all reasonable safety precautions. But those are the considerations that need to be balanced, and you really just, in those situations, are making a tough business call between how badly you need the employee in the workplace. This last question, who should you notify? I want to just hit this one really, really quick. You do want to notify employees if somebody has been tested positive or has exhibited symptoms, but do it without revealing that person's name, if at all possible, and keeping in mind that employee's confidentiality as much as you can. And there's some good guidance out there from the Department of Health on how to work through those kinds of situations and what messages to communicate and to whom. As I mentioned early on, here are some of the key government websites that I would suggest keeping a close eye on a daily basis if you can. Of course, the CDC, it has issued some interim guidance for businesses and employers, and there's a link there. The Department of Labor has coronavirus resources, and once we get some guidance on the FFCRA, that's where you will find that. Their poster and their FAQs are available at the Department of Labor's website. The EEOC has also issued guidance that it's updated as recently as March 21st on pandemic preparedness. It's really focused on these ADA considerations. And for those with Ohio employees, check out Ohio Department of Health's guidelines for screening employees with COVID-19. I think PBPO will probably have a lot of these resources available on their website, and our law firm has a COVID-19 resource center as well, where all of those links that I just provided are available, along with a variety of other resources. So I know we're at the hour. I'm happy to stay for a few questions for any of those who want to stay on the call.
Mike, how are we doing on time from your perspective?
So to be honest, I'm a little concerned that we're going to lose access to the system within about 2 minutes. So I know there's lots and lots of questions. So I'm going to unmute Erin real quickly so she can talk about some of the next steps and additional resources that can be available through pro bono partnerships, some of the stuff that she mentioned earlier in the webinar. Erin, can you kind of remind us of that?
Yes, everyone, thank you. I have been cutting and pasting all of your questions into a document. Many who are clients, please feel free to reach out to us. We'll make sure that those questions get answered for you. If you're not clients, please think about applying to be clients. Reach out to us if you have any questions about being clients or just questions that you have in general. We'll try to put together kind of a weekly FAQ on employment law questions and put it on our website. We are happy to email out the slides, and again, as soon as this webinar can be available for download, both United Way and Pro Bono Partnership will send it out. So Liz, thank you again for your time. Mike, thanks for making this possible through United Way. And thank you all on the phone and